Now, as DUI defense lawyers, when we conduct a DMV hearing, we really have two goals. The first, of course, is we want to win the hearing. We want to get the suspension set aside. We want to keep your driver's license intact. And there are literally about 25 ways to challenge the DMV case against you. Usually this comes down to errors that the police make in their investigation and their paperwork and the police reports. And trust me, police make mistakes all the time. So it's our job to identify it and use it to your advantage. The second goal of a DMV hearing is to prepare the case for court. I often say that the DMV hearing is like a dress rehearsal of the court case. So in preparing for the hearing, we can subpoena or obtain vital evidence in the case, such as the police officer's dash cam, surveillance tapes, radio dispatch logs, the maintenance and calibration history of the breath test that you used. And oftentimes, through the DMV, we can get this evidence even before the prosecutor does. We can also subpoena in the arresting officer, put them under oath, and question them about everything that happened in the investigation, getting them to admit mistakes that they made, things that they did that are not consistent with protocol, things that you did correctly, things that you did consistent with sobriety. Oftentimes, we can get very favorable testimony out of the police officer. We can then get a transcript of that testimony and take it to the prosecutor and to the judge and use that as leverage in court later on to get a better deal. Or if the case goes to trial, we're all the more prepared. And keep in mind, in a criminal case, and in particular a misdemeanor, which most DUIs are, there is no deposition. Often there is no opportunity to get a crack at cross-examining the police officer until jury trial. But if you do the DMV hearing correctly, then really you get a chance to depose the police officer early on. And you would be amazed at the sort of things that they say that can be useful in the court case. In fact, 9 times out of 10, when we get a charge reduced or dismissed, or we get a great result in court, or we get a not guilty verdict at trial, it's by virtue of what happened at the DMV hearing and by virtue of the testimony that we're able to get out of the police officer early on during the DMV hearing. Unfortunately, many DUI lawyers are very dismissive towards the DMV hearing. They think it's a waste of time. They think it's hopeless. They don't put a lot of effort into it. And that's a huge mistake. It's a huge missed opportunity because a really good, effective DUI attorney knows that you should take full advantage of the DMV hearing because it's a chance not only to try to save your client's driver's license, but really to prepare the case for court and oftentimes lay the groundwork to get the charge reduced or dismissed in court.